Hi friends, so I am continuing the question answers for AIB 2011. So the first part, which is subject 1, alternative dispute resolution, ADR, and the first question is, an arbitral tribunal should usually consist of an odd number of arbitrators, though if the parties continue with an even number of arbitrators, the parties are deemed to have waived their rights to challenge a commonly award by such an arbitral on the grounds that there was an even number of arbitrators. So it's better to have an odd number. And then in an arbitration agreement, the arbitrators have to be appointed by the international chambers of commerce. And then an arbitration agreement is a condition precedent for a valid arbitration under the provisions of the Arbitration and Conciliation Act 1996. With reference to a substantive agreement between parties, the answer is the arbitration agreement has to be separately agreed upon by telex or by email or in writing under section 7 of the Arbitration and Conciliation Act 1996. Means through three things it can be agreed upon, either by telex, email or in writing. So that is important. So that is there. Now question number 4. Under the Arbitration and Conciliation Act 1996, the rules of the procedures for a domestic arbitration has to be prescribed by the court of competent jurisdiction. It needs to be prescribed by the court. Civil contract. So category B, civil contractor A enters into an agreement with an architecture firm B to design a building. ओके एक सिविल कॉन्ट्रैक्टर है ए जिसने एग्रीमेंट किया एक आर्किटेक्चर फर्म से बी टू डिज़ाइन अ बिल्डिंग. Further, all the matters in relation to the design of a mall in the same building were subcontracted to another architecture firm C, under which the chief architect of the third architecture firm D had the power to remove any difficulties, including with regards to modification of any plans for the mall's design. The parties sought to get an interim order under Section 9 of the Arbitration and Conciliation Act 1996. Will the parties succeed? So this is the fifth question, and answer to this is an interim order under Section 9 would be possible depending upon the circumstances. So this is the right answer. An interim order under Section 9 would be possible depending upon the circumstances. And an interim order. So now question 6 says A and B enters into a valid arbitration agreement in relation to share purchase agreement. Okay, so they entered into a valid arbitration agreement in relation to a share purchase. So as per the agreement, any dispute in relation to share purchase between A and B must be referred to as sole arbitrator. And thereafter A and B have a dispute in relation to share purchase. A and B refer the matter to a sole arbitrator. The sole arbitrator passes an award in favor of A. B is aggrieved by the award as he believes that the arbitrator misinterpreted a provision of the agreement relating to the delivery of the shares. B wants to appeal on this ground. So the principle is there is no right to challenge an arbitral award if the composition of the arbitral award or arbitration procedure is in accordance with the agreement of the parties, even though such composition or procedure is contrary to Part 1 of the Arbitration and Conciliation Act 1996. It is not open to challenge the arbitral award on the grounds that the arbitrator has drawn her own conclusion or has not appreciated the facts. So the answer to this is C. B can appeal the award before the Supreme Court. It can appeal before the Supreme Court. So question number 7. A and B entered into shareholders agreement for the management of company X. They agreed that if the company X is wound up, they would split the profits in a manner that is in accordance with Companies Act 1956. They agreed to subject themselves to arbitration in case of any dispute with regards to the winding up of the company X. What will be the result if the dispute arises? Principle: the power to order winding up of the company is conferred exclusively upon the Companies Act 1956. And answer to this will be 7th. It will be like they can proceed only after confirmation from the company law board. कंपनी लॉ बोर्ड से कन्फर्मेशन आना चाहिए, तब हो जा सकते हैं, ठीक है। नाउ सब्जेक्ट टू द सिविल प्रोसीजर कोड, ओके, CPC 1908 and the Limitation Act 1963, okay. An ex parte decree implies that dismissal of suit on grounds of being barred by limitation. Dismissal of a suit on grounds of being barred by the limitation, okay. Then you have question 9, which is Limitation Act 1963 prescribed limitation periods for various kinds of proceedings. For a proceeding which is not specifically provided for in the schedules 9E, the period of limitation is as it may be prescribed by the High Court. As it may be prescribed by the High Court. The period of limitation is as it may be prescribed by the High Court. Okay. A court may pass interim or interlocutory orders. 10th question C. To allow the parties to appeal in a higher court. It may pass interim. So basically, Limitation Act 1960 prescribes limitation period for various kind of proceedings. For a proceeding which is not specifically provided in the schedules, the period of limitation is as may be prescribed by the High Court. This is question number 9. 10th is a court may pass interim or interlocutory orders to allow the parties to appeal in a higher court. Okay. Got it? Question 11. Filing a caveat before the court would mean that the second. Okay, question 11. Okay. So इसका आंसर ही नहीं बताया उन्होंने, इसमें कहा है छोड़ दो. Okay. Well, I can just say that caveat amateur have learned, but then it is different. Okay, category B, I'll go by that. Company A registered in Mumbai owns a property in Chennai. Okay, it is registered in Mumbai and owns a property in Chennai. The company took a loan from bank established in Kolkata, mortgaging the Chennai property. The company registered in Mumbai owns a property in Chennai. The company took a loan from bank established in Kolkata, mortgaging the Chennai property. Okay, the company defaulted in repaying the loan and the bank decided to foreclose the mortgage. Which of the following option is most correct? 12th question. This is E, which says the courts of Mumbai will have exclusive jurisdiction. Courts of Mumbai, since it is registered in Mumbai. Okay, the courts of Mumbai will have the exclusive jurisdiction. Okay, A and B, two Indians have a dispute in relation to delivery of goods and payment of money in a trade from India to England. An English court decided on the matters in favor of B based on the principles of natural justice and applicable international commercial laws, including in respect of jurisdiction. B decided to institute a fresh suit in India. Which of the following is most correct in such a situation? Okay, 13th. This is A. So it say B can institute a fresh suit in India provided the English court is a court of competent jurisdiction. So basically there were two Indians, there was a dispute in relation to delivery of goods and payment of money in a trade from India to England. An English court decided on a particular matter in favor of B based on the principles of natural justice and applicable international commercial laws, including in respect of jurisdiction. B decided to institute a fresh suit in India. Okay, so B can institute a fresh suit provided the English court is a court of competent jurisdiction. Okay, A filed a suit against B for a trespass on A's property. However, A fails to prove the trespass. In an appeal, A takes the leave of the court to produce an eyewitness, A's guard, who is willing to appear before the appellant court. A had tried to make the guard an eyewitness before the lower court as well. However, the guard had left the country at that time. And despite several summons being issued, had failed to appeal before the lower court. So, which is the answer? 14. B. The Court of Appeal may ask the lower court to reappreciate the evidence and pass a fresh decree. Okay, subject 3, which is constitutional law. Category A. Which of the following is correct in relation to formation of a new state from the territory of existing state? Achha, this is, so you must be knowing. So I think D. 15 D. Yeah. Article 3. Parliament may create a new state from territory of existing states under Article 3 of the Constitution on the recommendation of President, and if the bill for this purpose has been referred to the legislature of the state affected for their views, and the time period for receiving such views has expired. Right? So this is there. Question 60. Which provisions of the Constitution gives the state authority to provide for reservations of appointment or post in the services under the state in favor of a backward class of non-citizen, which in the opinion of the state is not adequately represented in the services under the state? I think this is for, I have heard, 15.4, that is C, I think so. Let's see. Okay, it's D. Article 16 subsection 4 of the Constitution. So this is for provisions of Constitution gives the state authority to provide for reservation of appointment or post in state in favor of backward class. Okay, so it's 16 subsection 4. Which of the following writs may the Supreme Court use to inquire into legality of a claim that a person asserts to public office, and to remove such a person from public office if the claim is not well founded? This is for me, public office is mandamus. Let's see. 17. It's mandamus, right? A writ of mandamus, right? Good. Which of the following is most correct in respect of a money bill? Money bill. 18th A. Money bill may only be introduced in the House of People. Once it is passed by the House of People, it is sent to the Council of States, which may send it back to House of the People along with the recommendation and proposed amendment, if any. The House of the People, however, is not bound by such recommendations and proposed amendments. Okay. Category B. A 5-judge bench of Supreme Court passes judgment in a matter. In a later case before the High Court, the party presents the Supreme Court judgment as a binding authority. The opposing party claims that the High Court is not bound by Supreme Court's judgment because relevant provisions of law were not brought to the notice of Supreme Court in that case. Which of the following is most correct in this case? 19th question. C. So a High Court cannot ignore the decision of Supreme Court on the grounds that relevant provisions of law were not brought to its notice. Okay, under Article 141, it is bound by the decision of the Supreme Court. Okay, Company A made sales of bricks which were supplied from outside the state to several purchasers within the. So let's stop it here.